Namaste and a very warm welcome viewers to this new episode of Legal Tips by the Indian Lawyer and Allied Services. I am Sushila Ram Varma, Chief Consultant at the firm. Today we are going to deal with a topic which is very common in the commercial world. This is what is known as the check bouncing case. Now, what does check bouncing mean? It means the dishonor of a check which has been given by the payer to the payee and has not been accepted by the bank. Checks can be dishonored by a bank for 5 reasons, namely insufficient funds, damaged check, if the date is not correctly put, if there is a mismatch in the signature, and if there is any overwriting in the check. Now let us understand what happens when the check bounces. When the check bounces, it gives rise to a cause of action for the payee to approach the court. Generally, in a case, the judge can levy a penalty that could be twice the amount of the check or imprisonment which could be 2 years. The judge could also levy both penalty as well as imprisonment. A check that bounces can either be of an individual or a partnership or a company. Now, when the check belongs to a company and it has been dishonored, it is not just the company that is liable, but the people who are managing the day-to-day affairs of the company would also be held liable for the same. Now, what happens when a check bounces? A check can become an offence only upon a written complaint by the complainant before the magistrate. The magistrate then takes cognizance of the offence and the case starts for a check bouncing. Viewers should, however, note that though I have already mentioned that there are 5 reasons as to when a check can be returned or dishonored, it is not as if they have a cause of action for every return of check. A check which is returned for insufficient funds is the right cause of action for approaching the magistrate for dishonor of checks. Now, what is it that a payee has to do when he gets notice that a check has been dishonored? The first thing that the payee must do upon receiving such notice, and that is within a period of 30 days from the intimation of the bank, issue a legal notice on the payer informing him that the check has been dishonored and that he or she is called upon to make the payment. This notice, which is issued, is a notice under Section 138 of the Negotiable Instruments Act. Once the payer gets the notice, he has a period of 15 days to make good the loss of the payee, failing which the payee has the option of approaching the court. Now, the next question is, how do you know as to which court you have to approach when a check bounces? That is, which court has the jurisdiction to decide your case? There are 5 ways in which jurisdiction can be decided: where the check was drawn, where the check was presented for payment, where the payment had to be made, where the check is dishonored, and lastly, where the demand notice was served. Now, coming to the most crucial part of your case, which is the evidence. All viewers must be aware of the fact that in law one can win or lose a case based on the evidence. Hence, one must always be very watchful and mindful when collecting the evidence. In this case, the evidence would be copy of the notice served on the drawer, proof of service of notice to the drawer, original check on record, check return memo from the bank, and proof of the existence of a legally enforceable debt or liability. One last question before we wrap up. Many viewers will wonder whether a check that has been dishonored once can be represented to the bank. The answer is in the affirmative. Yes, you can represent the check provided you are sure that the payer has sufficient funds in the bank. If you have found this video helpful, please like, share and subscribe to our channel so that we may be encouraged to make more such videos in the interest of the public. Thank you.